also from the executive branch. Mr. Michael Horowitz is the Inspector General in the Department of Justice Office of Inspector General and has held that position since 2012. Under his leadership, the OIG issued several reports about compassionate release. Before joining the OIG, Mr. Horowitz was a partner in the Washington, D.C. office of Cadwalader, Wickersham, and Taft. Like Mr. Wroblewski, Mr. Horowitz also served as a commissioner from 2003 to 2009. It's hard to believe it was that long ago, and was the department's ex officio member prior to that. So you know us well. Welcome back.
And it's good to be here. Thank you for having me testify on this important issue on for the past several years, my office has identified overcrowding in the federal prisons as one of the top management challenges facing the Department of Justice. We've even referred to it in our reports as a crisis that the department is facing, something the department, I think, itself has acknowledged. As of December 2015, BOP facilities were 20% over rated capacity, and its inmate to correctional officer ratio remains troublingly high. The BOP has the largest budget of any Justice Department component other than the FBI, accounting for 26% of the department's budget. Over a quarter of the department's spending goes to the BOP. And it employs, sorry,
thank you.
That good? And the BOP employs 37% of the Justice Department staff. Almost 1 out of every 4 Justice Department employees works for the Federal Bureau of Prisons. Inmate medical costs are a major factor in these rising costs. In FY 2014, the BOP spent $1.1 billion on inmate medical care, an increase of almost 30% in 5 years. One reason for the growth in medical costs is the aging inmate population. Inmates age 50 and older are the fastest growing segment of the BOP's inmate population, increasing 27% from 2009 to 2014. By contrast, during that same period, inmates under age 50 decreased actually by approximately 3%. To help address the burden of both overcrowding and prison costs, we've found in our reviews that the department should more effectively utilize programs such as compassionate release. We've issued 2 reports recently addressing these issues. In 2013, we issued a report that assessed BOP's use of the program from 2006 to 2011. And last year, we issued a report that assessed the new BOP provisions expanding compassionate release eligibility for inmates age 65 and older. In our 2013 review, we found the BOP's compassionate release program had been poorly managed and implemented inconsistently, resulting in, among other things, deaths of inmates waiting to have their applications considered. We also found on average that only 24 inmates were released each year through the compassionate release program. Our review also found that the department had not evaluated recidivism rates for inmates who had been granted compassionate release. The OIG therefore undertook such an evaluation and found a recidivism rate of about 3.5% for inmates released through the compassionate release program. By comparison, the BOP has used the general recidivism rate, and the department has, for federal prisoners, an estimate of as high as 41%. As we noted in our report, the OIG recognizes that approving and releasing more eligible inmates through the compassionate release program could result in some increase in the number of inmates who are rearrested. But we also noted that the recidivism data we found demonstrated that a carefully and effectively managed program could minimize the risk if careful consideration were given to an inmate's potential risk to the community as part of that assessment process. On the same day we issued our report, the BOP issued its new compassionate release statement that sought to address the issues that we identified in our report. In 2015, we issued our second review, and in that one we assessed, as I noted, the department's modification of its compassionate release program statement, which sought to expand the number of elderly inmates eligible to apply for compassionate release. The program statement was released on the same date in August 2013 as part of Attorney General Holder's Smart on Crime initiative. In the first 13 months after the BOP announced this expansion of compassionate release eligibility for elderly inmates, we found that only 2 inmates were released under the new eligibility programs. Specifically, we found that 93 elderly inmates applied for the non-medical provision, resulting in 2 releases, while none of the 203 inmates who applied, elderly inmates who applied under the medical provision, had been approved for release. As I learned earlier today from the testimony, it appears that that number has now grown as a total to about 30 inmates, elderly inmates, in the 2.5 years since the statement released, which is obviously somewhat of an increase, but hardly a significant increase in the number of inmates who have been released under these new provisions, announced as one of the pillars of the Attorney General's Smart on Crime program. Based on the results of our review, the OIG found that the BOP could do more to improve its compassionate release program, much like we had found in our review from 2013. Our report made a number of recommendations that the Department and the BOP should consider, including one that would lower the eligibility age from age 65 to age 50. Multiple studies, including one published by the BOP's own National Institute of Corrections, recommended that inmates be considered aging starting at age 50.
It's sad to hear.
I agree completely. I was struck by that as well when I learned that fact. But according to the studies, an inmate's physiological age averages 10 to 15 years older than his or her chronological age due to the combination of stresses associated with incarceration and the conditions an inmate may have been exposed to prior to incarceration. Indeed, 7 state correctional systems from around the country have defined aging inmates as those inmates who are age 50 and older. We found that lowering the eligibility provision to age 50 could assist the BOP in addressing its overcrowding issues, particularly in its minimum and low security institutions where inmates age 50 and older represent 24% of the population in FY 2013. We also found that reducing the eligibility age could result in cost savings. We found that based on BOP's cost data, BOP spent approximately $881 million, or 19% of its total budget, to incarcerate aging inmates, those 50 and over, in FY13. We also recommended the BOP consider eliminating the 10-year minimum time served requirement that they put in place with the new aging inmate provisions, so that all aging inmates would be eligible to apply for consideration for a compassionate release once they'd served 75% of their sentences. We found the 10-year provision excludes almost half of the BOP's aging inmate population because many sentences are actually too short to be considered for compassionate release under the provision. We were particularly concerned about this provision because it categorically prohibits early release consideration for aging inmates who did not receive at least a 10-year prison sentence, even though those inmates are likely to be the best candidates for early release consideration precisely because they were given lower sentences and almost certainly got less serious criminal convictions. Yet, and they therefore pose a less risk of danger to the community. Yet they are categorically removed from consideration under the policy statement. We found that taking both steps, reducing the age from 65 to 50 for eligibility consideration and eliminating the minimum 10-year requirement, would increase the number of aging inmates eligible, I use the word eligible, for consideration from 4,000 or so inmates to 30,000 or so inmates, based on that data that we had from FY 2013. We recognize that not all inmates age 50 and older are appropriate candidates for compassionate release. As a former prosecutor, I completely understand that concern, and that the evaluation will necessarily include many factors, such as the nature and circumstance of the inmate's offense, the criminal history, the inmate's conduct in prison, the inmate's release plans, and whether release would undermine the deterrent effect of the punishment imposed. Nonetheless, as we noted in our prior reports, the Justice Department itself has already determined that aging inmates are a low public safety risk as a general matter, which is why the provision was put in place. For that reason, we found that reevaluating the compassionate release eligibility provisions for aging inmates could substantially increase the pool of eligible inmates. And let me make clear that when I talk about expanding the pool of inmates, I'm talking about those eligible for a applying for compassionate release, not those that actually should be released. That's a decision that would be made, as the prior discussion indicated, through a variety of processes. What our reviews focused on were the eligibility of the applicants. Within that larger pool of eligible inmates, we believe the BOP could further identify more aging inmates who present a low risk to public safety if released, resulting in reduced overcrowding and cost savings to the Justice Department. Thank you, and I'd be pleased to answer any questions the Commission may have.
So if I jump right in, if we load it to 50, let's say we did everything you wanted, what about the basic argument? Well, we're at most hortatory to the BOP, you know, that the BOP has its own jurisdiction and could simply say no. What is your thought about the impact that a guideline change would be? You've studied this program.
Yeah. You know, from our standpoint, the issue really has been, and really what we're charged with is not making policy, but looking at how the department has implemented policies and handled the policies. And what we found in both reviews, that even under the standards that they put in place, it had not been managed effectively, and there wasn't clarity around the program. What we've also found is that, for example, in putting in place the 10-year rule, we heard about the danger and the risk that inmates let out under compassionate release, even elderly inmates, for example, would be potentially a danger to the community. And one of the things, as I said in my statement, we noted was, well, if that's a concern, the 10-year rule really makes little sense, because you are then only making eligible the most serious inmates for consideration, and that's going to result in numbers like we're seeing, which is, I understand the department noting that the overcrowding problem that they're facing can't be resolved simply through compassionate release. And that's certainly something that we've never in the OIG in our reports suggested for a minute. But what we have found is that it is one of the few tools the department has been given by Congress to deal with these issues on the back end, which are inmates already in jail who have served a lengthy period of their sentence. And what we found is that the department hasn't used that tool that Congress has given it effectively by putting the rules in place that they have, and by then even using the rules they've put in place in evaluating their program.
Well, I'm trying to figure out why the Bureau of Prisons or the DOJ is in some manner released from the very sorts of things that the sentencing judge has to do. As an example, when the judge sentences a defendant, one of the 3553A factors is the danger that this person presents to the community of future crimes. Okay. And we are taking a hard look at recidivism to see whether or not, given the sentence that's imposed, this person really does have a risk of recidivism. What I'm trying to figure out is, where does this 10-year come from? Where's the science behind the 10 years? I don't see it. I'm unaware of it. But is there something that the Justice Department or the Bureau of Prisons have figured out that 10 years? Because it looks to me that all they are saying is, we want to make sure that somebody receives an adequate punishment, and that for the most serious offenses, where a person has been sentenced to 120 months or longer, we want to make sure that they have done the 10 years. That's fine. That's a factor. And I don't have any quarrel with the punitive aspects of punishment. But if in fact what you are going to do is let people out because they otherwise qualify for release, I'm trying to figure out, where is the inquiry, where is the science based upon the 10-year rather than a 5-year or some other time?
In our review, we found no basis provided to us for why 10 years versus no floor, a 5-year floor, a 7-year floor, a 10-year floor. And of course, as you know from dealing with the guidelines, for an inmate to be considered for compassionate release or a good candidate for compassionate release, presumably would have had to have received good time credit.
I would say that any sentencing judge looking at this and looking at the criteria would say it's irrelevant. It's irrelevant to the consideration of what sentence I should impose, because because if it's going to be at least, the person has to serve at least 10 years, fine, okay. It's not my concern.
Right. And to add to that, if you've served at least 10 years, you probably got a sentence of at least 11 to 12 years because you need the good time to be considered. So you're really looking at people who got 11 to 12 or more years of a sentence who have to demonstrate that in order to be eligible. And we were not given any basis for why the 10-year number was picked. Frankly, one of the things we identified in both our first report and in the most recent report was a concern about the lack of data on metrics or other information kept by the department. Just generally on, for example, recidivism rates was the most obvious, but timeliness standards were not in place. We made that recommendation in our 2013 report. We're still waiting. That's still open, as you heard, and we're still waiting for that timeliness standard to be put in place. We found the possibility of inconsistent decisions across wardens in institutions because it's a decentralized process that's done at the warden level, and when we interviewed wardens, we heard varying views on what the standards meant to them, and that has resulted in multiple revised guidance being issued by the BOP, whether it's on medical conditions or otherwise. So that's been a concern in a number of areas that we've looked at in terms of how this program has been managed.
Just one quick question and one other. Did you receive your request to get the minutes of the meetings of BOP with their various stakeholders? I know you'd asked for those by July 31st, 2015.
Yeah, on that, that's the recommendation in our most recent report where we asked for a report by July 31 of last year. What we learned was that the group was not constituted and didn't meet until December of last year, December 2015. We were given a PowerPoint presentation that was used as part of that meeting, and we're told that that was in essence the record of the meeting. We're obviously disappointed that we're going to be coming up in April on the one-year anniversary of the issuance of our report, and the working group has just gotten started and, to our knowledge, hasn't made much progress.
So the follow-up to that, or the related question to that is, so there's a couple different things that we're looking at this hearing. One is kind of what the substantive standard should be, but in some sense, it doesn't matter if the process by which BOP processes these is just so delayed and riddled with inconsistencies among wardens, things like that. And so even if you, for example, change the eligibility so that you didn't have to serve 10 years, you had to serve 75% or some percent of your sentence, whatever it was, there's this question of whether or not any of that really means anything if the process at BOP has various places in it where it's not functioning on all cylinders. And so from your experience studying it, in terms of improving the process at BOP, is there anything related to that you can see that we could help with if the standards were clearer? I mean, putting aside they may just view them as advisory in any event and not pay attention to them, but is it the lack of clarity that is a problem for the wardens on a case-by-case basis that slows them down? So Dr. Williams' suggestions would be helpful. Is it that there's some other, what could the substantive standards do, I guess is what I'm asking, to help improve the process? Because it seems like a lot of the things at BOP are out of our control. We can't dictate how they process these kinds of things. But could we help with the clarity of our standards?
I think what we've looked at is the BOP standards themselves in the policy statements and any supplementary guidance. We found the BOP has responded to the concerns as we've identified them and tried to address them. And so, for example, they've issued multiple new guidances on medical conditions and considering medical conditions, but that we found remains an issue, and we found that in our most recent report, as a source of confusion. We also found that what was seemingly clear in the statement about it being 10 years or 75% turned out to be a conflict. I mean, 10 years is 10 years and 75% is 75%. There shouldn't be much room there, but what it turned out to be the case was that the word or was really and. And so the BOP had interpreted the statement to be both requiring 10 years and 75%. And we found that the wardens and others who had to handle the statement to be confused by that issue.
That's because they have it which
whichever is greater at the end of
Right.
that hunt.
Right.
Can I just, we're so data-driven, so, as you know, that the staff put together statistics on recidivism at different age groups, which I thought was very helpful in trying to understand what should be the right age. So between 51 and 55, there's a 26.8% recidivism rate, whereas if you're over 65, it's a 13%, about half. So I do understand that we should take into account the very learned testimony of the experts on geriatrics, something I'll probably be increasingly leaning on. However, in terms of recidivism, it's really a stark difference, the age 65 to 50. And at what level, so we can't totally say it's irrational to pick one versus another in terms of public safety. Did you look at, maybe you didn't have access to this.
We didn't have access precisely to that, but we did have access to general studies that indicate the same issue, which is why we undertook our own recidivism review on the compassionate release program, and we're,
But you can understand why it's 3.5% if they're only taking people who are about to die. I mean, so as you say, it would likely go up. But if you made everyone eligible, you might see statistics like that after age 50.
Well, the issue is, of course, making more people eligible doesn't mean that those are the individuals that would ultimately be approved for release, and that's, I think, one of the things we've seen is that by categorically restricting the people who could be considered, you're potentially losing individuals who, in fact, are among the sickest and among the perhaps safest to be released. And so, for example, just in terms of data, 65 and older in medical institutions, and this I'm using our 2013 data that we had, there were, at that point, 582 of the 4,000 plus 65 and older inmates in medical centers. So those are among the sickest individuals. You heard testimony that 1,600 inmates are in stage 4 facilities, which are among the sickest. And yet, if you consider how many elderly inmates total in 2.5 years have been released under the program, we're talking about 30. So we're talking far less than 1% of those sickest individuals. Many of those may be, and I don't know the answer to this, but many of them may be because they're absolutely barred from being considered because they haven't yet served 10 years of their sentence.
So it's a 10-year rule, you're really...
Well, I think that was the starkest one that stuck. That eliminates half the population. So whether you choose age 50 or 65, if you have a 10-year rule, you basically cut in half the number of inmates eligible to be considered right off the top. They just can't be considered, period.
Two quick questions. One is, I think DOJ testified that, or someone will, that almost 60% of BOP's older population began serving their sentences after age 50. I'm just curious, if we were to drop the age limit to 50, do you have any thoughts on whether or how it should affect those who are sentenced after that age?
Well, I think the 75% rule still stays in place, right? So no matter what age you're sentenced at, whether it's 50 or 65, there's still this, you have to have served 3/4 of your sentence. So it's not as if it's a get out of jail free card because of your age. Right. It's when should you be considered by the BOP and ultimately by the sentencing judge for consideration for possible release, given all of the potential concerns, severity of the crime, inmate's history, medical condition, deterrent need for the sentence, other factors the judge and the BOP need to consider. So it's really what we've looked at, just to be clear, is not about who should be granted compassionate release. It's about this issue of, is the program being run well, and do the categorical decisions being put in place make sense given the data we're seeing?
One thing we've heard from the past from BOP is that for those inmates who need significant medical care or life-threatening illness, one of the reasons they're not releasing them is they're having a hard time finding a place for them on the outside to have the care that they will need. And is that something that you found in your investigation? And if so, what percentage do you think that accounts for some of the folks dying in prison?
Yeah, that was a concern, and it was a concern we heard about in our reviews. We didn't get data on that from the BOP. I'm not sure if they now have such data. That was, among the various issues of trying to sort through this was the data issue. But that is clearly an issue that needs to be in place. There has to be a release plan, which is, again, why, in our view, as you sort of put in place restrictions on who can even apply, you're potentially shrinking the pool of people who you might think did have release plans in place. But that is clearly a legitimate and very important reason and concern.
Anybody have any other questions?
I'm puzzled. It seemed to me, you've looked at our proposed amendment, right? And the circumstances, in our list of circumstances, number 4, we have the 65-year requirement for a defendant who suffers from a chronic or serious medical condition related to the aging process. Mm-hmm. That's someone who served at least 50% of his or her sentence. It would seem to me it'd make a lot of sense to lower that age for that circumstance. But when you look at circumstance 5, which I think is what Commissioner Friedrich was referring to, that has the 10-year requirement, dispensing with the 10-year requirement might make sense. But if the only other circumstance other than having served 75% of his or her sentence, even with inmates being older than the average age because of their circumstances, it doesn't seem to me that just that lowering the age in that circumstance to 50 would make sense. Do you think otherwise?
Well, I think on this issue and these considerations, I think the real question is how broad a pool of eligible applicants do you want to try and create? Because between age 50 and 65, you have about, if I have the numbers here, there are 14,000 inmates who are over 50 and received less than a 10-year sentence.
Right.
So you have that group. And then you have inmates age 65 and older who have received less than a 10-year sentence, is about 2,000. Now, all the data I'm using, by the way, is from FY 2013. So you have these relatively large numbers as you consider, say, 30 people total being released in 2.5 years. You have 2,000 inmates over 65 who have been excluded because of the 10-year rule.
Right.
And to us, that made little sense,
right,
particularly when the chief argument that we heard in opposition or as a concern about compassionate release was the safety issue, which is obviously a very legitimate issue. Right. But the people who got age 65...
Lowering the age requirement in that circumstance doesn't make nearly as much sense, does it, as it would for those who are suffering from the serious or chronic medical condition and have served half their sentence.
Mm-hmm. Well, certainly you can make the argument that the latter makes more sense of the two. We're not in a position, frankly, to make a policy judgment on it. We're much more in the point of laying out what the numbers look like and allow others, like the department and like policymakers such as the Commission, to decide what the right place to set things is.
Yeah, isn't one of the issues that BOP has is that they have limited resources in order to evaluate all these different requests and all the different factors, and in particular, those release plans that we've discussed, how complicated those are. Isn't that an issue? And wouldn't broadening the eligibility pool make that even aggravate that problem, making it perhaps harder for the BOP to then identify which of those applicants are actually more deserving of the release?
Well, I think we've found and heard concerns from BOP about staffing levels and the support and ability to go through them, but I don't think, frankly, that should be the basis for not having considered for this program those who are eligible or should be eligible for it, or who are the sickest inmates. It frankly argues for the department putting more resources into addressing these issues. We found in a number of places, frankly, in our aging inmate report, which went beyond the compassionate release program, where BOP needed additional staffing in a variety of areas to support aging inmates. And so from our standpoint, the answer should be the department making an evaluation to consider whether to give more resources to the BOP rather than just not handling the program the way it needs to be.
But my question is really about broadening the pool, and wouldn't broadening the pool exacerbate that problem?
And I think at that point it just becomes a question of whether the department is supportive of the program and going to put in place the resources to address it. It's certainly been our concern that the way the program has been handled, as we saw in 2013 and more recently, that the timeliness has been an issue. We found that, in our first report, that about 13% of the inmates had died while waiting to have their compassionate release application be considered. 28 out of, I think, 200 or so, pretty high number. So something the department, we think, and the BOP needs to address.
I'm sorry, I wasn't going to ask a question, but
Last question, please.
2/3? Your analysis is that 2/3 of these individuals have died while they're...
No, I'm sorry, 28%, a quarter of them. I'm sorry, 28 out of 200 or so, 13%.
13%. Okay,
I'm sorry.
Thank you. I'm sorry. I
Died. That was under, to be clear, the old program, the program that was in place prior to 2013 when we issued our report.
Well, thank you very much for testifying and for all the work you've done in this area. Why don't we all stand up and stretch as we hit our the third